Good morning, everybody. Back, at least for today. We have a very full day today. Today is Tuesday, the 29th of July. And I hope I remember how to do this. I've been gone for 6, 7 work days. I had a vacation that probably will last a lifetime. And it does sometimes get to be time to get back to work. Everybody should be able to spend a week on Mackinac Island in the middle of the summer, because it's as good as it gets. Anyway, thank you to Judge Pattison and the rest of the staff for covering while I was gone. I'll be here today, and then I'll be back Friday for the first Friday of the month, pre-trials, and then we'll sort of be back to normal. Got a nice email from my friend in Scotland. Thank you for that. Got a nice card from Charles. And thank you for that and all your good wishes. It's hot everywhere. It was sort of hot at Mackinac Island. Not as hot as it was everywhere else, but it was really nice weather. The Chicago to Mackinac boat race was during this week, so it was crowded with yacht people, so we try to stay away from them. Judge Pattison has the pre-exams this morning. Mr. Stickley is here, Mr. George is here, and it looks like we're ready to get started. Apparently nothing too terrible happened while I was gone. Morning, Mr. Stickley.
Good morning, Judge.
Good morning, Colin, who's been here to visit a couple of times. Thank you for getting up early. Also dog sitting for my son, who's still at Mackinac Island. I was up early, like 5 a.m. walking the dog. So let's get to it. Thank you all for saying good morning. I check out Coolin with Colin's YouTube channel. I heard this morning that it's hot everywhere but San Francisco. They've only had 2 days this summer in San Francisco over 70. Like, yuck. I hope it's not that cold in Berkeley. Oh. All right, let's see who we got here for customers. Good morning, everybody. You guys are here for an arraignment. My name is Judge Middleton, and I get to have my name there. This gentleman is Mr. Keith Stickley. He is the Chief Public Defender for St. Joe County. And Bailiff Michelle is here to help us today. Lost Mr. Jeremy to 3 Rivers. He got traded for a draft choice of player to be named later, and they sent him to 3 Rivers. Anyway, we'll be okay. All right, I'll get right to it. Let's start with Mark Wittenberg. Will you come forward, please? Podium there, sir. I've been gone for a few days. Let's see if I remember how to do this. This is file number 251. Yeah, first thing, Michelle tells me I need to turn the record on. She's on it. See, I already forgot. Thank you, Michelle. This is file number 251382SD. You're Mark Bradley Wittenberg?
Yes, Your Honor.
Mr. Wittenberg, you got charged with operating while intoxicated almost every day. We have at least one of these. In Michigan, it's a misdemeanor. It's punishable. Okay. By up to 93 days in jail and a fine of up to $500.
That's good.
It was red.
It's red, then it went to green. One is recording, the other one is not. Unfortunately, I think I need to shut it off again.
Oh, boy.
Yeah.
Well, this isn't the time to do it 1 minute before showtime. All right, we're having problems with the recording equipment. Hasn't been used in 7 business days. And we didn't check it this morning. We just got up and hit the road. All right, everybody bear with us. We might have to reset
It
this.
will take.
Do I have to shut down?
Yes, please.
I have to shut everything down?
Well, let's try with this without you doing that first.
No. $27 days credit. All right, this is the time and sort of time and date for the sentence in Joshua Allen Oddinger. Mr. Oddinger is charged in this count originally with assault with intent to commit great bodily harm, interfering with a crime report, and domestic violence. He pled to the domestic violence charge. Then there was another charge of domestic violence, which was dismissed for a plea to malicious destruction of a building while I was gone. And Judge Pattison gave the defendant 17 days. Defendant pled to domestic violence first offense. He admitted squeezing her forcefully. I asked for some victim input and some other information. I was advised by the prosecutor's staff with an email when I got back that they'd been unable to find a complaining witness. The defendant is here with his lawyer, Jordan Yancey. Also present is Gary Gabriel from the prosecuting attorney's office. I crammed this in the middle of Ms. Yancey's duty week because I was gone and then I was going to be gone again. So thank you all for your indulgence. Ms. Yancey, what would you like me to know here?
Thank you, Your Honor. As the court has indicated, Mr. Oddinger has been in custody since the time of this incident, so he is entitled to 27 days credit. I don't show that he has any real significant criminal history until as of late, so I would ask the court to consider simply imposing fines and costs at this point. I don't know if probation is necessarily appropriate. Sounds like Mr. Oddinger has indicated to me that the relationship has ended. And for the prosecuting attorney's office, the victim is somewhat transient. So I don't think this is going to be an issue where the parties are back together at any time. He's trying to gain employment and get on with his life. So I would ask for time served, fines and costs, and resolve the matter that way. Thank you.
Thank you. Mr. Gabriel, you got any additional input on this one?
Just indicate, Your Honor, in reviewing the police report, I would concur that it seems like both of them are somewhat transient. The lady was homeless, he's homeless, they were together in a hotel for a while. I think it's described as being an off and on sexual relationship. Word friends with benefits in here somewhere. Looks like meth's an issue. Parties seem to have at least separated for now, and no idea where Miss Simmons is. It seems like Mr. Oddinger and her can't seem to keep their hands off each other when they get angry. So I would leave it to the discretion of the court. I would tend to agree that we probably would not be utilizing the limited resources of the court if we tried to put him on probation. He knows what he did was wrong, and he's either going to stop doing it or he's going to do it again.
Mr. Oddinger, where are you going to go when I let you out?
I'll be honest, I was going to probably try to go back home.
Where's home?
Elkhart, my mom's.
All right, that might be for the best to get out of this situation altogether. All right, I'm gonna.
If I may add, I was planning to go back to rehab too.
Well, you got 29 clean days. You're gonna get a couple more. But I'm not gonna, as Mr. Gabriel said, put a bunch of effort and resource into this. You're gonna move on, and maybe Elkhart's a good place for you to be. 27 days jail credit, 27. I'm gonna zero the fine. I'm gonna wipe out the attorney fee, but I'm gonna do the crime victims' rights fee and the state minimum fee, $125 or 2 additional days. Somebody will pay $125, you can get out. I'm not gonna chase you for this. It's a mandatory state fine. It's not even supposed to be eliminated by jail time, but we'll call it good. So hopefully somebody will post it and you can get out. Otherwise, you may be there for 2 more days. All right, you're good to go, sir.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Gary, one of the things about that picture was the people that aren't with us anymore that are in the picture. He's,
Our guest, Jeff.
yes, he's in there and several others, but he sent it to me yesterday and I thought, I know somebody would like to see this. So I'll be happy to know your picture is up somewhere in the back hall of the Grand Hotel.
Yeah, I saw that Jeff's successor, Lloyd,
Yes.
I guess he's making noises about running for AG as Republican. See what happens.
Judge, are you doing the pre-trials on Friday?
Yes,
Oh, are you,
I did it for you.
okay, I have 19, so.
Yes, I came back from my vacation just for you.
So you're going back for a little bit and then coming back?
Yes.
Okay, well, safe travels. See you
No,
Friday.
I'm not going back. I'm
Oh.
back
Staycation.
vacation. I'm too far to drive back and forth to Mackinac Island, but I am back.
Okay, I'll see you Friday.
All right, thank you. For the people on the live stream, this must be really frustrating, but trust me, it's really frustrating here. For other live customers, thank you for your patience. I think we're up. It had to do with the sequence of which the system was booted up. I'm not exactly clear what happened, but that's what happened when you go on vacation. So I set these matters for the middle of my vacation. I came back today to deal with some things, and including these 2 matters. So I appreciate your patience. I have Tanya who's there, and I have Samsung SM. What's your name, ma'am?
Cassandra Strawser.
Okay, that's what I thought. Maybe we'll get some rhythm here once we get up and going. All right, this is file number 231359. This is entitled Neighbors of Washburn Lake versus Cassandra Strawser. Mr. Nicholas Borden Sanford is here from the Palitz Law Firm. He was here last time. Also, the manager, Tanya, is present. The other manager was Julie. Tanya, are you on this one?
Yes, Julie Daler is no longer with our company, so I'm the district manager filling in for her until we get another on-site manager.
Thank you. All right,
Thank you.
we had a hearing on July 16th where we found that rent was $2,559.43 through July. Rent last paid April. Mr. Borden Sanford, what's the status here today?
Your Honor, we have not had been able to discuss a resolution, and we're still showing the amount due and owing, inclusive of court costs of $2,756.97.
2,756. 97 cents. 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 97 cents same as last time. Um, Ms. Strawser, what's your position?
I have my money order receipts back from March saying that I'm up to date paid. I made a rather large payment, end of February to get myself caught up. I wasn't able to use their, online, payment plan. So they told me I could send it to their PO box, send a money order. And I was never told that I could not continue sending money there. But I have been since March. And when I got this paperwork in the mail, I was unaware that any of this was happening.
So are you saying you've paid rent? April,
Yes, sir.
May, you paid April, May, June, July's rent?
Yes, sir, I have.
Paid it to where?
I have a PO box that they said that I can send it to in their package. It was Neighbors of Washburn Lake, PO Box, New York, New York, and I have an account number.
And how did you send the payment?
Through the mail. It wasn't allowing me to make payments
All
online.
right, so you sent a certified check through the mail?
Yes, I sent a Western Union.
Tanya, I don't have your last name. What's your last name?
Stransky, Stransky.
And I've never met or spoken to Tanya. I did not know that Julie was not with the company anymore. That explains why I have not been getting responses via text messenger.
Well, when we were here 2 weeks ago, you indicated you tried to contact the manager. You have money orders back to March show that you paid the rent. So
Yes,
it's the same thing you said last time. Your contention is you've paid the rent. Their contention is you have not. And you have the receipts for that?
Yes, well, I don't understand if they received April. I don't know why they didn't receive the month before, March. And they must have received my earlier of the larger payment to get caught back up in February. But yes, I have
you're
Western
saying-
Union.
All right. Do you have the receipts there in front of you?
Yes, I do.
All right. Tell me, go through them starting in April.
They're the is there any way I can like flip my camera so you can look at them?
Well, just read them to me at this point.
Okay. I have a money order receipt, two of them totaling in $410. For the March, same thing for April, May, June. And I've paid up, my July was sent also.
All right. And you have all those receipts in front of you?
Yes, I do, sir. Judge, I don't know.
All right. Okay. So I'm not sure what to do with this except continue it. We may have to have a hearing.
And Your Honor, if I may, the last payment that was received from the community was through a lockbox as a Zigo transaction, and that was taken for on on April 7th for $410. However, the balances continued to accrue due to the lot rent, the water sewer charge, late fee, and each month. So the payments of $410, and as the defendant has outlined, would not be enough to cover the ongoing monthly obligation.
I've never, I'm sorry to interrupt, but I've never
Stop. I'll give you a chance to speak. Don't just blurt things
Okay,
out.
I'm sorry.
All right. Go ahead.
Yep, and Your Honor, as I was stating, that the payments have not been enough to cover the outstanding balance. It seems like she's been carrying, over $1,000 per month in a balance, and so she'll make a payment. However, that is not enough to cover the balance that is due and owing.
So are you telling me that you've received her payments of May, June, and July?
As reflected in the ledger I have in front of me, Your Honor, it seems that no payment has been received to the community since April 7th, 2025, and that was for $410 via a Zigo payment.
Zigo,
Yes.
that's a proprietary name.
Yes, that is. I believe that's a payment method that tenants can make at grocery stores, and as well as, I believe, getting a money order through that.
All right. So we have a fundamental issue of, I did get your brief, by the way, in support of non-payment of rent cases in mobile home communities, hopefully at some point. So we have a fundamental dispute here. She says she paid the rent, you say you didn't. Then you may be correct, even if she did pay the rent, there may be some additional costs regarding late fees or utilities or other things. But the claim is that she's paid no rent since April 7th, and she says she's paid April, May, June, and July's rent. Previous manager is gone. Ms. Stravinsky, is there a method that she described about sending payment to a post office box in New York? Does such a thing exist?
Were you talking to me? I'm sorry.
Yes, yes.
Yes, there is such thing as a lockbox that they can send money orders to. We actually try to discourage it just because it does take a little bit sometimes for us to reach them, but not anything like this many months by any means. We've not had any phone calls from her. Julie just stopped working for the company on Friday. So, you know, her notes were pretty caught up. We've not had any conversation with Cassandra at all, with her bringing in all of those receipts to prove that she has paid those so that we could look and try to find them. We've not heard from her at all.
Is there somebody in the office?
Yeah, me. We don't have an office on site at Washburn. We don't have an on-site office, so she would have to reach out to Julie through that number, and then Julie would either meet her at that location, or we do have a couple of offices. We've got one at Stanky that's 7 minutes away from Washburn that she could come down to.
All right.
I never know.
All right, go ahead, Ms. Strawser.
Okay, the previous that you were saying, that April payment through a Zevo, whatever the lawyer, I have never used any of those kind of payments. I have always used Western Union. When the park was sold not too long ago, I have a phone number and I have text messages in my phone that I thought I was communicating with Julie, and she just stopped texting me back one day, and I have never met Tanya. I had no idea there was a stinky resort that I could, you know, go give this stuff to. I did not know this information.
All right, well, you're all going to win a free trip to the courthouse in Centerville and sit down here in a trial and establish how much this is. Or you can try to meet with each other and see if you can come to some sort of an accounting. We can't do this by Zoom. Mr. Borden Sanford's never been to Centerville. This may be a free trip. You can have lunch at Yoder's, but we can't do this from here. So let me look. Because I've been on vacation, my calendar is quite crowded.
Looking forward to the trip, Your Honor.
All right, we can continue this to Friday, August 15th. At 11 a.m. live, not Zoom. If the parties are able to resolve it, they can submit a conditional order of dismissal.
I would love to do that. I would love to have your phone number, Tanya, so I could actually speak to you or meet you somewhere and get this resolved.
I'm okay with that. We can do that. That's not a problem. Let me give you can I give her my phone number now, Judge, or would you like me to wait?
Wait, I'm gonna put you all in a breakout room here in a moment after we take care of the other case. So everybody stay with me.
Okay.
Anyway, for now, this is continued for a live hearing. Ms. Strawser, meaning you need to bring any and all receipts that you have that you contend have been used to be paid. They will try to do a further accounting. Now, there may be some other issues. There may be late fees. You may contend I shouldn't have a late fee because I paid it. We'll see. So stick with me for a moment. We got behind schedule because of our technical difficulties. But let's talk about neighbors of Washburn Lake versus Melinda Weaver. I don't believe Melinda Weaver is here. We were here last time, and we made a finding that rent was $1,990 plus court costs gave us $2,187.54. Is that still accurate?
Your Honor, the defendant had made a payment since the last hearing, I believe, on or about July 24th, 2025. And so her rent to retain is actually $1,440.00.
1440?
Yes, and then
Through
court
July.
costs. Yes, through July, Your Honor.
All right, the court costs we determined were $197.54.
Correct. So the total due and owing would be $1,637.54.
All right, I don't believe I have a judgment. It would be helpful if I did, but I don't think I do.
I could submit one after the hearing. That's more convenient.
Good morning. What's your name?
Melinda Weaver.
All right, Miss Weaver just came in. Why don't you come up here and have a seat? This was set for 9:45. She's way late.
I've been waiting. I was waiting in that other room since 20 after.
Oh, okay. Well, I wasn't aware of that. All right. Well, Melinda Weaver is here. Have a seat right there.
Right here?
Yes, thank you.
Okay.
All right. Mr. Borden Sanford says that you made a payment on July 25th, which has reduced the amount of rent you owe to $1,440.
Yeah.
You accept that?
Yeah.
All right. Court costs are $197.54. All right. That's why I wish I had a judgment. I could just hand it to her.
I apologize, Your Honor.
Well, you appear in a lot of jurisdictions and some judges do it differently. We like to have a judgment. I
have a money order here made out to him for $800.
All right.
And I have.
Now, just a minute. Tanya, how would you suggest they go about paying with a money order?
Well, the problem is we're pretty much everybody gets online and pays through those cash apps they can do a cash app, they can go to Walmart, they can pay them that way. when they mail them and they mail those money orders to a corporation, they have to almost mail them 15 days before they're due so that they hit the office for them to be able to be in our system before they hit late fees. They have to take into consideration with the mailing of that, mailing them all to New York. So we try to discourage people from ever doing money orders because of the getting lost in the mail and all those things. So we have put out lots of information on all the different ways
That
they can
didn't
pay.
answer my question. Can she simply go to Stanky Resort and pay that to somebody?
She can bring it to me. That would be fine.
All right. Do you know where that is?
No. Where are you?
It's in Burr Oak. So it's 31500 Stanky Landing in Burr Oak, Michigan. We're literally 7 minutes away from Washburn, from that community. I just drove it yesterday. Wasn't even 7 minutes.
Okay, give me your number.
All right, I'll put you all in a breakout. So,
Okay.
all right, let's do the judgment. Through July, rent is $1,440. $197 in court costs, so the total through July is $1,637.54. Now, she's got $800 that she wants to pay to somebody.
I also have a blank check that I get paid on the first
Okay,
of
all right.
August.
Well,
I can make it out.
you're gonna have, of course, August 1st, another month's rent is due.
I know. That's why I want to
But,
go ahead
all right,
and do it today if I can.
very good. So you have 10 days from today, which would be August 8th. I've been studying this a little. Mobile home parks have changed.
I used to pay it. There's a wash house, used to be a wash house behind where my trailer is. And I used to go and stick my rent in there, and then whoever owned it would come and pick it up.
All right, well,
Me too.
the trailers, mobile home parks were all mom and pop operations and locally owned, locally operated. 6% of people in the United States live in a mobile home community, which is 22 million people. And within the last 10 years, most of these parks are being bought up by large corporations. So,
For tax write off. I know.
well, I don't know. It's changing. And so it's gotten more expensive to live there, but the companies are making improvements that many didn't. So people like you that have lived there for a long time, used to handing a check to somebody, those
I lived
days
there
are
for
changing.
18 years.
All right, please don't interrupt me.
I'm sorry.
So the rules were different 18 years ago, and it was locally owned, and people are struggling all over the country. Mostly struggling because the prices are going up substantially. So mobile home were sort of a last resort for a lot of people for low income housing, but it's changing and they're becoming modernized and professionalized and more expensive. So, Mr. Borden Sanford, I'd like you, if you would, to email me a judgment in this case. The address is on the pleadings. It's at 3B Civil at St. Joseph County MI .gov. 3B Civil at St. Joseph County mi.gov. It's right there on the notice. And if you email me that, I'll do it. Now I'm going to put all of you in a breakout room. Miss Tanya, you can give her the information about where she can actually go to give somebody the check. Sounds like she's ready to pay her rent in full. And Cassandra and you can make arrangements to further discuss things. But I think that finishes your cases for this morning, Mr. Borden Sanford.
It does, Your Honor.
All right, I'm hopeful they can resolve that. You guys won't have to be here live, but I'll be here either way. So I'm going to put you all in the breakout room.
Okay.
Okay, thank you.
Thank
And,
you.
Thank you.
And Miss Weaver, I can't put you in a breakout room. Because you're here with me.
Oh,
So, give her that address again, Tanya.
31500
wait a minute, 11,
31,
31, or
500 Stanky Landing. It's STEINKE Landing.
N-I-E, Tiny Landing,
Landing.
Landing,
Yes.
And that's Burr Oak, Michigan.
okay,
And I'm going to give you my phone number. Is that okay, Judge? So that you can just call me if you got the wrong address. That's 574-381-7668.
7668,
Correct.
okay.
All right,
What's your name? Tanya?
Tanya.
Yes.
Okay,
All right, Miss Weaver, when I get that judgment, I'll get it to you, but it sounds like your intention is to pay the rent. And that will be good.
I've been in the hospital and I don't have anybody to take care of my money.
All right, well, it sounds like you want to deal with it, so you can go drop that check off over there and pay the other check and you should be good.
Okay,
All right, thank you. I'll send you that judgment when I get it. All right, the rest of you can go into the breakout room. Cassandra, hit the
Yes.
button that says join.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Sending that judgment over right now, Your Honor.
All right, Miss Weaver, you're good to go.
I'm good to go.
Yes, thank you.
I thank you very
All right,
much,
thank
sir.
you. All right, we're behind a bit. Mr. Bradshaw is with us. And you're good to go.
Okay, I'm gonna dismiss this.
Our next scheduled case is St. Joe River LDHA versus Diana Coy.
And I'd like to dismiss that case, Your Honor. Ms. Coy made that payment she just made that payment today.
Okay,
I'm confirming it today. She paid it yesterday. So I'll prepare a dismissal.
all right. Thank you. All right, that helps us catch up a little bit. That was 10:10. All right, next I have from you Three Rivers Limited Partnership Medallion Management versus Kelly Pedler, 251432FT. You submitted a conditional order of dismissal. We'll
Yeah.
work out payments or vacate by August 11th. Is that
Yeah.
correct?
That's correct. Sorry. The key provision is that she'll vacate by August 11th. She did state to me that she wanted to make payments and she wanted that included in the order, that just to show that she's making a good faith effort on that part of it. I told her when she vacated, she could contact the development and make some sort of arrangements to pay that past due amount. But the key provision is that she was going to be vacated by 8/11.
All right. You guys are fortunate enough to have missed out on all of our technical difficulties this morning. We had all kinds of problems, which have put us behind, but I think we've got some sort of rhythm now.
Okay.
So our next matter is Enchanted Glen. I think, does that finish you, Mr. Bradshaw?
It does. Thank you so much. Have a good day.
Thank you. You have one too. Hopefully, we'll all get through this. All right, next up is Enchanted Glen versus Nicole Anzaldua. Nicole Anzaldua is here, and Greg Popovitz is here on behalf of Enchanted Glen. And the manager is here. When we were here last, we determined that through July, rent was $875.14 plus $222.69 in costs, making the rent in July through July with costs $1,097.83. Mr. Popovich, what's the status here today?
Hello, Your Honor. Gary Popovich appearing on behalf of Enchanted Glen. We are here for the second hearing. I have rent. I'm not sure. I really appreciate Your Honor having notes and reflecting upon the first hearing. That means that's I appreciate that from a practice standpoint. We have rent though under her current ledger through July 11th. As I have notes reflecting it was $2,145.14. And that was what was emailed this morning by the manager to me. But we are on this, we do have a consistent reflection as to the court costs. The court costs were filing fee of $90, court's mailing fee of $13, service fees of $44.69, and a statutory attorney fee of $75. I also know that Ms. Anzaldua, since the last hearing, has not made any payments and has not made, and it has not reached out, to my knowledge, to legal counsel, which were some of the rights that were read to her at the first hearing.
Well, we're way off. I made a finding, or we took some evidence that rent was $732.14, and then we added $143 for $875.14. What you're giving me now is double what we had discussed at our last hearing. The rental rate is $143 per month. As of March 25 through March, rent was $283.14 plus late fees. So the defendant paid $490 on July 10th. We're going to have to calculate this because, well, Ms. Anzaldua, unmute your microphone if you would. Good morning.
Good morning.
You were here on July 11th. Was that your understanding that you owed $875.14 through July?
I had it written down. The last time I knew I was only supposed to pay like 1,000 and something.
Yes, that's right. So, Mr. Popovich, what is your contention rent is now?
As of today, from the property manager, it is $2,145.14. And that was the most current ledger through, and then it's July 11th and the rent hasn't changed. So I'm looking back at some notes, Your Honor, I'm looking back at some emails from the earlier hearing just to see if I can help clarify. And then if you don't mind, potentially the manager could provide some clarification given the figures and her better understanding of the ledger.
Yes. Could you state your name?
It's Kim Shaw. Well, I printed the ledger off this morning because I knew I was going to have needed to have an updated ledger. And on the ledger that I printed this morning, they've added the 940 to her ledger she has not done her recertification.
Oh.
She hasn't signed for her new lease, is where I'm assuming that's where the 940 is coming from. I just noticed it this morning, like I said, when I printed it off.
Okay, and Your Honor, I had not, so Ms. Shaw and I had communicated by email. I had not seen an actual ledger. She had emailed me the balance. So that amount we can get into that through testimony if we need to. And I do reflect, I have emails from 710 reflecting that the amount of rent due as of the time of the last hearing was 7/11. The amount of rent on the ledger was $1,122.14. that didn't include any of the attorney fees or statutory fees. And that would have included a full month of July's rent. And that would be, we're here now on the second to last day of July. So I think that's the amount. And then Ms. Shaw, can you just provide me a little more clarification as to, because you're getting this ledger from corporate, obviously. So that's when you're referring to they are the corporate, and they've added, what is the $900 figure that you mentioned has been added?
The 940, from what I'm assuming, is because her certification was supposed to be done back in June, I think it was. Let me see. I think her ledger was due to be signed. Hold on. Might have been. I'm trying to see if I can find her file. I think her ledger was to be signed back in June. January, February, March, April, May or June. And because she hadn't recertified to renew her lease, I'm assuming that's where that 940 came from. She doesn't get the rental, that's not with her rental assistance. That's what she would be paying for rent.
Would it be safe to say that there's a market rate increase that she has now had retroactively applied by corporate because of her failure to have the recertification?
Yes.
So, but the ledger does reflect, and otherwise would have reflected, that through July, based on the earlier rent figures, she would have had a balance through July of $1,122.14, correct?
Correct.
Okay. All right.
Give me that number again.
$1,122.14.
Defendant contended that she paid $490 on July 10th. Is that reflected anywhere?
Yes, it's on her ledger.
All right, so let's go through this. The pleadings say that through March, defendant owed $283.14. Her rent is $143 per month.
$10 late fee for every month that it's late.
Yes, plus 20. So we'll get to that in a minute. So 283 times plus April, May, June, and July's rent. I really hate doing this in this manner, but we'll have to see if we can get 143 times 4 is 572 plus 283.14 is $855.14. Do that again. 143 times 4 is $572. So as of April 1st, she owed $283.14. So if we add in April, May, June, and July's rent, that's $572. We add that to $283.14, we get $855.14 plus 4 late fees, which is $80. Which is $855.14 plus 80 is $935.14. She paid $490 in July minus 490 is, oops. Should be 445.14. When the plaintiff contends, it's 2,145.14. I'm not sure how.
For clarification, Your Honor, the $900 figure has been articulated, meaning that there is, since we were here at the last hearing, corporate has retroactively increased her market rent because of the recertification. So I'm running with that on the fly, and I need to look at the ledger to understand that a little bit better, but that would explain at least part of the difference from the figure I mentioned at the beginning of the hearing to the number you just calculated. I'm just as concerned right now, not concerned, but curious as to, I appreciate your math and running through that because that is consistent with the figures in the complaint that was prepared by our office. When we came on the 710, the communications were that there was a balance of $1,122.14, not including fees. So would it be okay, Your Honor, if I had a breakout room with my manager and she could email the ledger and her and I could.
Well, what she says, I assume this is where this came from. This is just some magic number. Oh, by the way, between our last hearing and now, corporate says you owe an additional $940. For what? So much per month, a $940 lump sum? They retroactively raised all the rent. No wonder she's confused. Legal aid's not here to plow the water.
I understand. I understand that confusion. That's why I want to talk with my manager so we can, it's not, the manager's getting the information from corporate. I understand. It's not a magic fix. I know what's happening. I've had some experience with this in the past. When somebody fails to recertify, corporate ends up in the review process, ends up upgrading the 143, let's call it in this case, to what's called market rent, and then it's retroactive. I understand that we're here on a second hearing, though, in our hands. There is some equitable view of this that's going to be taken by the court as to what amounts were disclosed to this young woman on the first hearing versus today with that amount. I'd like to, Ms. Shaw, if you could email me a copy of the full ledger, I'd like to dissect it, you and I in a private breakout room, and then, Your Honor, we'll be back. We'll come back in and we'll move forward at that time.
Ms. Anzaldua, you stick with us. I'm going to go ahead and take up some other cases. We'll do Centerville Mobile Home Park versus Harley Poling. Harley Poling is here. Ms. Poling, can you hear me?
Yes, I can.
And the manager.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
I'm a P33, so we're about the same vintage.
Well aged.
And the manager, Joshua.
He's under Kyle, asset manager, and also the property manager is here as well.
Well, we worked on this last time, and they sent me a brief again regarding lot rent only for mobile home parks. I got one from another law firm, and I've been on vacation, so I haven't had a chance to read them carefully. But there's a contention that you can't do this, but they're arguing that you can. But anyway, we determined through July, rent was $2,224.44 plus court costs of $170.05 for a total of $2,394.49. What is the current status?
Your Honor, that amount is still correct.
Well, again, at least we matched. We were way off on the earlier case. They're still working on that. Miss Poling, what's your position?
I have $1,100 that I can pay today.
Well, that's a good start. All right.
I can pay.
Now,
hang on, I have 100 I could pay today.
how much?
700.
All right. Well, through July, you owe $2,224.44.
Right.
$170 in costs for a total of $2,394.49, and they'll certainly accept any and all payments. Partial payment.
They have closed my. They haven't allowed me to pay any kind of payment. It was either the full payment or no payment at all.
I'm not sure
That
about
would have,
that.
that would have to be the case up until entry of judgment, yes.
Yes. All right. Now, they'll accept any payment and apply it towards your arrearage. But the only thing that will cure it is paying the entire amount. Now, on August 1st, your rent is due for August.
Right.
Now, Mr. Landman, we've been discussing these non-payment of rent cases and mobile home cases. What is your judgment asking for?
Your Honor, the judgment is asking for possession only, with an order of eviction to issue after August 8th if payment is not made in full. And paragraphs 5 and 6 are checked in the judgment, reflecting that acceptance of partial payment will not prevent the court from issuing an order evicting the defendant. With respect to the propriety of a non-payment of rent action for a manufactured home park, it's specifically permitted, Your Honor, under MCL 600.5714. And I believe that the brief that we've submitted covers all bases as far as how a non-payment action under that statute differs and is distinct from a termination of tenancy action for just cause under MCL 600.5771. They're two separate statutes, and it's apples and oranges, really.
Well, you're evicting her from the lot.
That's correct. We are evicting her from the manufactured home site that she rents. She still owns her home.
I was told I did not own the home.
Well, I don't know whether she has title to the home or not, Your Honor, quite frankly.
I do not. I was told that I still owe $2,000 on the home.
Well, I don't know the answer to that. You may have someone you're purchasing the home from. I'm not evicting her from her house. You can come get a moving company and take the trailer off of there.
That's exactly that is exactly the remedy available to my client, Your Honor. That's right.
That's what I believe the solution is.
Terribly sorry to interrupt, Your Honor.
Yes.
My name is Kyle Evans. I'm the asset manager of Centerville Mobile Home Park. Ms. Poling does not own the home. She is on a rent-to-own agreement with us, where she is paying us $300 a month towards the remaining home loan balance. So technically, the home is still in our possession until that loan amount is paid off.
That's also very common, but this is lot only. This isn't a foreclosure on the mobile home.
It is not a claim and delivery on the home. That's correct, Your Honor.
This is confusing, Ms. Poling.
Very.
Well, the bottom line is you're substantially delinquent in your rent. And
we've been working all the overtime, picking up extra hours, trying to saving all we can.
All right. And maybe you heard me earlier. The whole mobile home market has changed in the last 10 years. And I'm seeing dozens of tenants like you who are getting overwhelmed by the modernization of mobile home parks. They're no longer locally
It's the late
owned.
fees, honestly. It's the late fees that get us every time.
That's not just in mobile homes, that's everybody. Once the late fees start, you get behind, you get farther behind. And we talked about this last time, it just sort of snowballs. But you've got a loan and you're purchasing the mobile home on installments, and you rent the lot. Lot rents have gone up across the country substantially, everywhere, including here. Some of it is good in that they're making some improvements in the properties, and some of it is not good and that the tenants can't afford to live there anymore. But this is lot only. There's a dispute whether they can even do this, but the relief they're asking for, I believe they can ask for. Your mobile home is on their lot and you're behind in the rent, and they're asking you to pay it or they're going to remove your mobile home. Now that may be an idle threat because A, it's very expensive to remove a mobile home, and the truth of the matter is they aren't very mobile. More than 90% of mobile homes that are cited are never moved again. They're not like, if you don't like it, you can pick up your mobile home and move it somewhere else.
Right.
That's
And
not
this
a
is an
very,
older mobile home.
I'm guessing this probably be very expensive. And plus, where do you put it? You
Right.
gotta move it someplace. So there's
You gotta
another
have,
way.
you gotta have land.
Yes. Well, you can't site a mobile home almost anywhere on a single lot. You can no longer take a mobile home and put it out on a 1 acre lot in the country. Most townships won't allow that. They will allow it to move to another park, but almost nowhere will let you site a single wide mobile home someplace. So I said the world is changing, and it's difficult for the tenants. At any rate, Mr. Landman, if you would send me that judgment.
I will email it, Your Honor, to the address that you provided.
All right. Now, Ms. Poling, my advice is you stay in contact with your asset manager and the property manager, Jeshua. You've got two issues. You're behind on your payments on the house, and you're behind on the lot rent. This one is only lot rent. And
Well, see, when I get my statement, it's put together. It's not a separate statement.
let me look. Because if it's a I can't tell that they print these 4 to a page and you can't read the leases. You need a magnifying glass. 4 pages to a page. The date for all this to happen is August 8th, which is 10 days from today. So any payment that you make will be applied to any arrearage that you have. But I told you again, you have to pay the entire amount. And I think it would be easier for them to work out a catch-up plan with you than to try to move this mobile home off this lot.
Absolutely.
So you stay in contact with your manager. And
I actually, the only person I have contact with is Jay Sousa. Any other time that I try to call the other number, I don't ever get an answer or a response or anything like that. And I know that they're out of state as well.
Well, as I said, we had one earlier that are in New York, and the people at our end can't sort it out. And it's accelerating. This was a little bit. Now almost every single mobile home park in the county is now owned by a corporate entity somewhere else. We no longer have local council. We have out of area council. And the world's different, and you can't give them a check or cash. It's a PayPal or Venmo sort of electronic thing. And some people struggle with that. All right. My strong advice is you stay in contact with your manager. If you make any payment in cash, get a receipt. Okay.
Okay.
Do you have any questions?
So we're able to go make a partial payment at after court?
Yes.
Okay.
All right. Best of luck to you.
All right. Thank you.
Thank you, Your Honor. Have a great rest of the day. That's our only case today.
This is a work in progress, and both you and Mr. Popovits appear all over the state. But the district judges have been discussing this. Probably going to discuss it again in a couple of weeks at our district judge conference. But we need some help. We need them either to fix the statute or get a court of appeals opinion that tells us what the answer is. But I think the relief you've asked for, where you move the mobile home is the remedy. But it is confusing when you have a rent to own on the mobile home and lot rent. And this lady could benefit from some legal counsel, but we'll see where this goes. All right. I'll go back and struggle with our last case, but I'll see you guys next time.
Thank you, Your Honor.
Thank you. All right, Mr. Popovich is back. Let me close the breakout room. We finished the Centerville case. Joshua, you're free to go on about your business. All right, Mr. Popovich, where are we now?
Thank you, Your Honor. First, getting back to the conversation and your reflection on that mobile home issue, I do find that interesting. I do represent not quite as many mobile home parks as I do apartment complexes, but I do work, as you mentioned, all over the state. And I remember another, I think maybe that case or a similar case in front of you the last time I was in front of you. So I do, and I agree, it's a curious topic for sure. In any event, as it relates to, well, I appreciate your take on it because I think of the curious nature of it as you move forward with those types of cases. With respect to Enchanted Glen, I've went over the ledger with my client, and listen, we reflect or regard, we understand there's some confusion regarding the amounts. So what I'm prepared to do today is going back to your math. So on May 20, it's May, the complaint was signed in May. There was $283.14 due and owing. Rent was reflected as $143 a month. That means another $286 is due through July, plus $20 in late fees. That's a total of $589.14. What's clear from the ledger consistently is that Ms. Anzaldua did pay the $490. That brings the total amount due for rent to $99.14. We also would ask that the court cost, the $229, be, let me pull that up just so I have that for the court's record. The $90 in filing fee, the court's mailing fee of $13, the service fees of $44.69, and the attorney fee of $75, $222.69 due and owing. We'd ask that the judgment be for the $99.14 in rent, along with that $222.69 in court costs. We'd ask that she have 10 days to pay that amount. Ms. Anzaldua, you're involved in a situation that gets kind of confusing for both property managers. There's Ms. Shaw, who's new, comes into the property. This is different than a privatized landlord where your rent remains the same every month. There are some issues here because of your recertification, and they are complicated when you don't pay, meaning that your recertification has been stagnant because of the non-payment action. So what we're going to do is, if the court is so kind to grant the judgment for these amounts, because it's the most fair resolution for you today, I wanted to at least, and I told Ms. Shaw that I would say this on the record, it's imperative that you, to remove this $940 charge that's been reflected on the ledger for retroactive increase of market rent, that once you pay this amount under the judgment, I'll work with my corporate contacts. Your recertification will be allowed to go forward. You'll need to sign that. There will then be a revisionary history as to reducing your rent from the market rate back down to the subsidized rate. There will be a reconciliation of your ledger. There may be some accounting issues or some payments that may be required at that point. That will be handled and finalized once the recertification is finalized. And then that will be explained to you so you can have some opportunities to make arrangements for those payments. Your Honor, if we find ourselves back in front of you in the future after she's paid this and after the recertification, Ms. Shaw and I will come that day with a ledger that we are ready to dissect and explain to you on the record, and Ms. Anzaldua as well, so there's no confusion. In the interim, though, we hope that the court will agree with that this is a fair resolution given the form of the pleadings and the ledger and what information Ms. Anzaldua would have had before today, and we'd ask that we have a judgment for the amounts previously set forth and move forward in that fashion.
All right. What was the amount again through July?
$99.14.
All right. That's a substantial change. And the total of that. $321.83.
Are you
Now,
completing
Ms.
judgment,
Ansel,
Your
do
Honor?
it. What?
Just a clarification. Do you want my office to submit a judgment or were you completing one?
Please, no, they do things differently in different courts. My preference is to have the judgment in front of me. And I guess I should start. My local attorneys all give me a judgment, so I can do it right here and hand it to the people. And I haven't been vigorous enough about getting out of county council to give me one. But yes, so Miss Anzaldua, let's break this down. After we did all the calculations, we determined that your rent through July is $99.14. August 1st, you're gonna know another month's rent. The court cost is the filing fee, the service fee, the mailing fee, and the attorney fee. That's $222.69. So you owe $321.83. And you have until August 8th to pay that. Then you got to pay August rent too, August 1st. You need to go into the office and do your recertification. Once you pay the rent, you can get recertified and they take that $940 market rent charge off of there. Can you pay $321.83 by August 8th?
I should be able to. I can actually pay $260 today.
All right, well, that's a great start. All right, the date for the writ is August 8th. Partial payment will not prevent the writ of eviction. You have to pay the entire amount. And Mr. Popovits, I'd ask you to email me a judgment.
Yes, Your Honor. And just from his,
Yes?
Oh, I was just for clarification. The judgment will reflect that partial payments will not stop the issuance of an order of eviction. So Ms. Anzaldua just mentioned she's got an amount to pay. I wanted to clarify with her, the standard form would be that partial payments. So if you're going to pay that, it's fine, but just know that the full amount that's set forth in the judgment would need to be paid, and partial payments could end up being forfeited as to an eviction order. But it sounds like, I mean, we're at an amount that hopefully is feasible and you'll cure it and move forward with the recertification.
All right. Do you have any questions?
Just the exact amount I owe.
Well, you owe $99.14 plus $222.69 for a total of $321.83 through July.
Okay.
And you owe $143 for August. Now, Mr. Popovich mentioned this. There may be some other fees in here that they aren't part of this judgment. If you pay this, it will forestall an eviction. Then we can figure out what's what and get squared away as of August.
Okay.
All right. $321.83. $260 will go quite a ways to paying that off. But you have to pay the whole thing to cure it.
Okay.
All right. I'll await that judgment and we'll send it to you when I get it.
Okay. Thank you.
All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Shaw. Take care, everyone.
All right.
Thank you.
Mr. Worthington, are you there?
Yeah, I'm here.
All right. I'm waiting for the landlord to log in.
Okay.
Here they are now, I think, a minute late, but not too bad. I'm not sure who this is. Miss College, is that you?
Yes, it is, hon.
All right. Well, you're half an hour late for your hearing. We had the hearing at 11 and
oh crap, I had it down for 11:30. Crap.
No, it was at 11 and you have till August 8th to pay $5,900 in rent and court costs. What you expressed last time is you were going to be looking for a place to move to.
Yeah, and I also called DHS and it is pending, but they had to throw it over to the supervisor because there's a $1,200 charge or a minus.
I'd be amazed if they'll pay that much rent, but as soon as you get the judgment, you share it with DHS.
Okay.
All right,
Do
otherwise
you
you may
got
need to
my-
plan to vacate by August 8th.
Okay, do you got my mailing address?
Yes, we do.
It's the 700 Riverside Drive.
I believe that's the address on the lease.
No, the one on the lease is for here. And I don't get mail here in Pigeon.
Oh, 700 Riverside Drive. Michelle, would you make a note of that? Riverside Drive, what town?
Constantine.
Okay. All right, yeah, we did the hearing at 11 and we were surprised you weren't there, but the attorney's gone. He's already sent me the judgment. You owe a lot of money. If you can't pay the entire amount, you're subject to being evicted.
Yes, I know this.
All right, I'll send you that judgment.
My boyfriend's sister Barb's gonna help us out with it, so.
All right, very good. Hopefully that'll help you get squared away.
Okay.
All right. Well, I'm going to call this case Yesenia Sanchez Ramos versus Steve Worthington. This is a second hearing. We were here on July 16th. Mr. Worthington was here. He wants to stay there. He was getting mixed signals from Yesenia, who's the actual owner, and his husband, Santana, her husband, Santana. But the bottom line is they don't have a lease and the plaintiff wants them to vacate. Mr. Worthington, have you had contact with your landlord?
No, sir.
Yes, I did.
Oh, my wife did.
All right, tell me about that.
I was texting him after court and he sounded like he was going to work with us, said he was going to talk to his wife, and then I haven't heard
Just a minute.
anything.
She's here now.
RIA
Good morning.
at gmail.com.
Good morning.
Can you hear me?
Yes.
You're late for your own court hearing. We've been sitting around for 4 minutes waiting for you to show up. We try to do these on time. When we were here last time, you had expressed that you wanted the tenants to move. They're getting mixed signals from your husband. And there is no lease. What's your preference at this point, Ms. Sanchez Ramos?
I just want the people move out.
Okay. Yes. Yes.
All right, what I told you last time, Mr. and Mrs. Worthington, I'll repeat. If you move somewhere else, you need a lease. And Ms. Sanchez Ramos, if you're going to continue to rent these, you need a lease. But you don't have a lease, and she's the owner, not Santana, and she wants you to move. You have until August 8th to vacate, or you're subject to being evicted. You
Yes,
have
sir.
until August 8th.
I have a question.
Just a minute. I'm not ordering any money damages. I'm simply ordering that you move by August 8th. If they're going to sue you for money, that would be at a separate hearing. What's your question?
I was wondering if I could have until the 10th so I can have everything out and have the apartment cleaned.
Well, they can agree to do that. August 8th is a Friday. As a practical matter, they probably can't get the writ till the 11th anyway. But if you vacate by the 10th and everything's clean, you should be all right.
Okay, thank you.
All right. Now, when you move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease, so I don't even know if there's a security deposit or anything, but.
Yes, sir. I paid security deposit.
Okay, then this is about your deposit. You need to turn in the keys and give your forwarding address in writing within 4 days of vacating. And if you're out by the 10th and everything's clean, then maybe that won't be much of an issue. All right, do you have any other questions?
No, sir. They'll get a P.O. box address for the moment.
Okay, make sure he has that. Ms. Sanchez Ramos, please try to show up on time. We get kind of jammed up. This happened to be the last case of the day, but We'll be all right. All right,
All right.
everybody's good.
Do I have to turn in the address to you, sir?
No,
Besides
turn it into
them?
your land. The PO box would be sufficient for a mailing address. All right, good luck.
We will go on the record in the matter 25 CF 53, State of Wisconsin versus Laura Chamberlain. The state appears through District Attorney Kevin Schmidt in person. We have Renee Landgraf, who is appearing by video conferencing with approval of the court. Ms. Chamberlain appears by video in custody in Burnett County Jail. We're set here today in this matter for a bond modification request. The court has, I believe, received that document. Ms. Landgraf, for the record, what is Ms. Chamberlain seeking?
Your Honor, she's placed on a $50,000 cash bond back in March, I believe. She's been in custody for several months. We're waiting for a suppression motion hearing date at no fault to herself. We couldn't get it scheduled until October. She's local to the area. She's looking for a signature bond or a much, much lower cash bond. I am appointed by the Public Defender's Office, so she is indigent. And she is willing to reside locally. Her mother lives in St. Croix Falls.
All right. So what is she asking the court? You're indicating a much lower cash bond, but is there one that she would like the court to consider that she believes that she would be able to have the ability to post?
I think she said her mother could help her post $1,000.
All right, Mr. Schmidt.
I think the cash bond needs to remain high. I'm not going to totally rehash everything I said at the last bail hearing in late April. That related to reasons associated with, the severity of the charges, where posts bind over on the prelim, the strength of the evidence. I would just add that, yes, she doesn't have any criminal history, but what she has going on in Polk County represents, by my count, just going through the Polk County clerk notes, 5 or 6 findings of contempt over the past year and a half in Polk County. In fact, the basis of the suppression motion involves her being there, knowing that she was not supposed to be at that property anymore, in defiance of a contempt order from Judge Anderson in Polk County. She even called dispatch a day or two before then and confirmed the exact day and time she's supposed to be gone and still overstayed it. My concern is, yeah, she doesn't have criminal history. That's great. She does have some significant local ties. But the fact that she's been in this constant state of not following court orders in Polk, with the severity of the charges, with the strength of the evidence, draws great concern, especially when some of the contempts, at least one of them, seem to involve collaboration with co-defendant Zachary Chafee. I think the cash bond needs to remain high. Thank you.
And are you indicating that it needs to remain at what it's currently set at, or just a higher amount to assure her appearance in compliance?
I think it needs to remain at $50K. Honestly, I'm surprised she's saying she's indigent based upon the Polk County case. Just on those documents in that case, she should have assets and income. I don't know why she doesn't.
All right. And for the record, that Polk County matter you're referring to is, I believe, her divorce.
Yes.
Based on that, Ms. Landgraf, any rebuttal?
Well, again, Your Honor, that's a divorce case. That's totally different than a criminal proceeding where she could have a felony arrest warrant and brought in and have her bond revoked until we go to trial or until disposition. There was a lot of confusion in the divorce case regarding who has the property, who gets to sell it, who is staying there. I think that's completely different than a criminal proceeding, and she knows exactly what she needs to do here.
We are past bind over. The court did find that a felony was probably committed by Ms. Chamberlain, understanding that there's at least one serious felony here in which a potential could be 25 years of initial incarceration and 15 years of extended supervision means that this is serious. The fact that she doesn't have a criminal history does come into play. Hearing that there have been contempt issues does cause the court with concern. But understanding that the suppression hearing, again, I don't have any of the information. I don't know what is exactly going to be argued at the suppression hearing because I don't have the ability to look at the discovery. The suppression hearing is not until October 7th at 1 o'clock. I do believe that a higher cash bail is necessary and appropriate, at least based on the information that the court does have in front of it. But I would be willing to amend and modify at this time, at least to a $25,000 cash with same conditions. I'm not sure if that's something that she could post or would have the ability to post or look into, but $25,000 is a lot to lose and have a lot at stake if she were not to appear for court. So the court will amend and modify to that amount. I don't know her assets. I don't know what she may have access to. But at least at this time, and based upon those reasons stated on the record, I would amend to a $25,000 cash. We do have another hearing again scheduled for October 7th at 1. Is there anything else that we need to address at least at this time?
I don't believe so,
Not
Your
for
Honor.
me.
All right, thank you. Then we are adjourned.
Thank you.
Thank you.
Okay, the jail might not yet be here because they just log in early and it's not scheduled for 11:30. So I'm just gonna send myself back into the waiting room, and unless, is Ms. Solderbeck there? Can you hear me now? Yes, there she is. Never mind, we can go early. We will go on the record in the matter 24 CM 116, State of Wisconsin versus Cararissa Solderbeck. We do not have the state making an appearance. This is a failure to pay warrant. Ms. Solderbeck appears in person in custody in Burnett County Jail. We're set today based upon her warrant and her inability to pay. Ms. Solderbeck was brought into custody, I believe, around July 21st. This is a possession of THC forfeiture ticket type of matter. Ms. Solderbeck, I have an address of you of 1025 East Lane apartment. That's what I have. Is that correct?
No, I haven't lived there since 6th grade.
Oh, can I get an updated, please?
It should be 218 East 7th Street. Apartment 308, St. Paul, Minnesota. And I think it's 55101, if I'm correct for the zip code.
Okay, and can I just get a telephone number for you, please?
Yes, I think it's 320-279-5071.
Okay, Ms. Solderbeck, are you currently employed?
I am not right now. I'm actually just trying to get my life back together and get my kids and all that kind of stuff. So it's kind of been a bumpy route, but I do have a couple of places that I've been informed of since I've been here that I can go that they can help me get a job, like the Butterfly House and Ruth House and stuff like that. So.
Okay. All right, so you have been in custody 8 days, I believe.
Something like that, yeah. 2 weekends,
Okay.
I know that for a fact.
And have you gotten into trouble in Wisconsin before?
No, I normally actually don't go to Wisconsin at all. I normally just stay in my little happy butt in Pine City, Hinckley area. So it was just kind of like the wrong time, wrong person driving, and just like I didn't even know that I had anything to do with anything in Wisconsin. Otherwise, I would have handled it a long time ago when I did have a job.
Well, I am glad to hear that, all of the above. What I'm going to do is you've sat 8 days in custody, so I'm going to waive the amount that you owe. And I'm just going to do it as like a stay or pay type situation, because I believe 8 days in custody can't be easy.
It's not. It's definitely been one for. It's my longest stay in jail actually. So it's been a lot, but I've had really good company. Your guards here are really actually pretty amazing compared to the ones in Minnesota. So it's been a good stay, but it's been one that's well done for.
Well, I am glad to hear that. I'm not glad about the stay in jail, but again, I'm going to waive the amount that you owe, which is $330.50. I am very glad to hear about our corrections officers and our jail captain and lieutenant and everybody up there. They work so hard.
Yes,
and they do. They have a really good uplifting personality, and they try and keep it all uplifting. So I'm very glad that you've said that, and I'm very proud to have the people that we do have up there. It's a very difficult job, and I'm pretty sure I would not be able to handle that. So they do a lot.
Yes, they've been very busy here lately too. So they've been doing the best that they can, and they do get their job done.
I'm very glad to hear that. So you should be good to go, and you should be able to be released here today. I have what I need, the updated address and telephone number, and I'm going to waive again the amount that you owe for that ticket. And hopefully you're going to be doing what you need to do, getting your kids back, finding a job, having a stable place to live, and all of those things. And so keep on keeping on and taking control of your life.
That's been my saying the whole time, actually. Keep on keeping on. So thank you.
Well, it's good to see you, and I'm sorry that it had to come this way.
Yeah.
But it's good, and you're going to be on the straight and narrow and doing what you need to do. So thank you, and hopefully I don't see you again, and especially not in orange.
You won't. Thank you so much.
All right, thank you. Thank you, Mr. Lemons. We are going to adjourn, and we are done at least until 1 o'clock. And just so you know, I want to update you and let you know that our 1 o'clock doesn't appear that it's going to be all afternoon like it was scheduled for, that confidential case. So it is only going to be a short amount of time because a motion was filed. So just make sure you log into that other Zoom that I gave you, and it shouldn't take that long.
Okay, I will see you back at 1. Thank you.
All right, thank you. All right. We will go on the record in the matter 24 CF 162, State of Wisconsin versus Jack Fenton. This date appears through District Attorney Kevin Schmidt in person. We have Charlene Perrin, Defense Counsel in person. Mr. Fenton appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a motion to admit child audio visual statements for this case. I have reviewed the motion. I have reviewed the response from the defense. I have also reviewed the confidential flash drive, and I have opened it and signed it and dated it as I am required. Ms. Perrin, in your response, you indicated that for the most part, you do not contest having the audio visual information from the child or children. However, there is a few caveats that you wish to discuss or to argue in front of the court, I believe. You have the floor.
Thank you, Your Honor. Yes, I do think that the officer who did the interviews did a nice job of verifying that the children knew the difference between the truth and a lie. I think that's one important factor that the court has to consider. And so otherwise, upon review of the videos and review of the law, I don't have an objection. I do believe the younger child makes some statements about what other people said other than the defendant. So I believe those things are hearsay that should be redacted. And I think Mr. Schmidt and I can discuss that and redact those before those are played at trial. And then I believe there's a provision that the prosecution can provide a transcript Sometimes I've noted during trial that transcripts are provided to the jury as well. I'm not sure if Mr. Schmidt has determined whether he's going to do that or not, but I would like transcripts of the recordings as well. So I'm requesting that.
For the court scheduling order, it is a directive that if they are going to play a video, they must get a transcript of that video, not from my court reporter, but from another court reporter. My court reporter can do that, but depends on her availability. So it is in the scheduling order, not only for counsel, but for jury as well.
Okay.
All right, Mr. Schmidt, with a response to Ms. Perrin's statements here.
So technically the scheduling order says upon motion, the court can order transcripts. I have no objection to preparing transcripts and providing them to counsel. I would object to giving them to the jury. There's a reason one of the preliminary instructions is transcripts not available to jury. And it cautions heavily against ever doing that with the jury, because if they rely on a transcript instead of their memory, they've already done appealable error. So if Ms. Perrin wants them available for us to use, to refer to be able to like cross-examine witnesses, I'm okay with doing that, paying for it and providing it. I don't know if I can provide it if I do it through a court reporter. I think they would have, there's rules to that. I'd have to look into it. I think they have to pay a smaller amount is what the court reporters usually say. But I'm fine with that, just not admitting it to the jury or sending it as evidence. To the hearsay thing, the purpose I want to use the younger child is to corroborate what the victim said to her. That's the sole purpose I'm using it. Since I'm going to be using it after the victim goes first, it's not hearsay, because one of the exclusions of hearsay is someone's statement about what someone else said after they've already testified and been subject to cross-examination, and it's to rebut an implied argument of lying or fabrication. That's in 90808, I think is the hearsay statute. Let me double check that.
Yes, it is.
Yeah. So because I plan using it afterwards, anything EMA says about DAA, what she said to her, I think will not be hearsay. If there were other people's statements you're concerned about, I don't. If you articulate that to me, we could talk. But yeah.
So when I've been in other trials and there's been transcripts prepared, because sometimes it's difficult to hear everything that specifically children say during their testimony, during a video. Sometimes a jury is provided a transcript while the video is playing.
That's exactly my experience, and I've done it half a dozen times in trials.
Not to take back. So thank you. So the other thing is, yes, I was speaking partially to statements other people, the child said about what other people said other than the other alleged victim. But I also think the argument counsel is making is premature and would depend on how evidence comes in and what arguments are made.
I mean, DAA is going to play a video and testify that the defendant sexually assaulted her. The defendant can't not say that's false. Like, that wouldn't be a defense.
Well, you're talking about the victim. I think Ms. Perrin is speaking of the sister of the victim.
Right. So
right.
I guess I don't understand what her argument is.
Her argument is, it all depends on how the trial flows.
I mean, if I do DA first and EMA next, then it's just not hearsay is what I'm saying, because DA has already testified and been subject to cross-examination.
And I think think that's the understanding, but just in case it doesn't, is Ms. Perrin's argument.
Well, yes, and if I understand counsel's argument, counsel is saying that it's corroboration of what the alleged victim, the younger child is saying that her sister said the same thing to her. And so it's corroboration of what she said. And so if the defense claims that she's lying or something like that, that it's a consistent statement. And so I think part of whether that comes in or not depends on what the cross is of the alleged victim and how her testimony comes in.
Right. I'm understanding her flow. Are you?
I'm understanding what she's saying, but I don't think it makes any sense. Because like I said, the defense isn't going to argue that what DA said is true, that Mr. Fenton sexually assaulted her, which is why 90801 sub 4 sub A sub 2 offered to rebut an express or implied charge against the declarant of fabrication or influence or motive. That's what it's for. I think it's unreasonable to say if the defense doesn't ask a question or doesn't accuse the person of lying in the cross, that I can't offer a statement for that purpose. I think that's going a bit too far. Because no good attorney would just accuse a witness of lying on the stand. That's not how impeachment works.
I'm just not going to respond to that.
Well, the hearsay information is noted. I'm pulling up the statute right now. You said sub 1, sub 2? No.
Sub 4 in 90801, and then sub A sub 2. That is how statements corroborating other witnesses are introduced in trials, through that sub. And the one above it is how you introduce witnesses to impeach others.
90801 sub 4 A2 states consistent that the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive.
Yeah, so obviously the rules of evidence were not intended to prevent witnesses corroborating other witnesses by saying, hey, they said the same thing to me. That would be an unreasonable view of the hearsay statute.
Well, that is accurate and true. You can't corroborate. So are you asking me to make a ruling right now, or are you asking that this be open to objections determining on how the examination of, I'm just going to say the sister goes, Ms. Perrin?
That is, my understanding is that today is about whether the video would get in and then the ruling on whether, so, you know, we have no objection to that. So whether the video gets in as hearsay is a question that the court would determine depending on how things go at trial. That's my position. Because I don't think the court can make that decision until after the alleged victim testifies. I just don't think it's possible. That's my opinion.
All right, so based upon the stipulation of the parties, the video will be admitted and the court will wait until the trial to determine if there is an objection. And then the court will rule based upon what has occurred and then the objection made at the time, if any.
So just to clarify then, the only hearsay statement you were alluding to in your letter was EMA saying what DAA told her.
Right. I don't object to the other one at all. The older, the alleged victims.
I just wanted to make
video.
sure, because obviously there's some like mom said this, dad said this, not really relevant to the case at all. You know what I mean?
Well, I don't know if I believe that's not relevant, but that's what I was speaking
I'm trying to clarify what you're objecting to.
All right, I'm just hearing, what I'm hearing right now though, is that they're being admitted and Ms. Perrin will be doing her job at the trial. And if she hears anything she doesn't believe should be admissible and should be in the jury's review and under their consideration during the trial, she will object and the court will determine at that time whether or not the objection is sustained or overruled.
Yes.
All right. So that could be with any statement made by the parents. It could be any statement made by the sister. Again, I've reviewed the two interviews and I believe there were statements of the parents. I can't recall off the top of my head exactly what they were stating, when and why and how. So that's where we are with that, with the video. It is admitted with parameters of the rules of evidence during the trial. All right, what else do we need to discuss today?
I don't think there's anything else to discuss.
I think we can just briefly, I saw that Ms. Perrin wrote a letter because she knows that we're waiting for DNA results on an article of clothing of the victim. I only saw that letter this morning. I tried calling the lab. The analyst wasn't in, so I'll just keep everybody updated on that.
Okay.
And hopefully it won't be a problem, but I just wanted to just let the court know in case that it becomes a problem.
All right, so noted. And we do have the letter. I do have the information out from the DA as it relates to that DNA issue. And if we have to have a hearing prior to final pretrial to discuss it, we will, or we'll discuss it at final pretrial.
Actually, I have one more update. After I called, the crime lab called back and my secretary answered. They've done testing and they're in the process of writing the report. So we should have it soon. I don't know what the results of the report are yet based off of that note.
That's great.
All right, so then we should have information definitely prior to the final pretrial, which is set to occur on August 28th.
Then that should give me time to do what I need to do.
All right. Anything further that we need to address today?
Not from me.
No, thank you.
Okay. Well, then, thank you. We have our we have another status on August 12th, 2:15. I guess we can address any of the issues we have then, and then we have the final pretrial August 28th. All right. If there's nothing further, we are adjourned. Thank you.
Thank you.
Just, did the court say it did not want me to ask Corey to do the transcripts?
No, you can ask her. I can't guarantee she can do that.
That's all I had.
Stacy Lundmark does a lot of them. So you can always reach out to her too. All right, then we are adjourned. Mr. Lemons, our next hearing is at 11 this Zoom.
Okay, I will be there. Thanks.
Will now be on the record in 2025 CR 94, State of Kansas versus Michael James Shinkle. County Attorney Jill Gillette for the state. Michael Shinkle appears in person on one count of violation of a protection order. Give me just a second, please. All right, sir, you are here for first appearance. As I said, it is alleged that you violated a protection order issued as a condition of post-release supervision in GW 2025 DM 21. This is filed as a Class A person misdemeanor. If you were to be found guilty, your fine could be up to $2,500. Your jail sentence could be up to 1 year. Are you going to, this is a misdemeanor, are you going to hire an attorney, apply for court appointed, or represent yourself?
I'm going to apply for court appointed. I already talked to Richard Paul, and he said he couldn't do anything until I came.
Okay. All right. Are you employed?
Yep.
Where do you work?
I'm an independent flooring contractor.
A flooring contractor?
Yes.
How much do you make per month?
The last month it had been good, but it's going to be a little better next month.
So it varies. Do you know how much you put as your income on your tax return for the past year?
Somewhere around 25,000 last year.
Are you married or single?
Single.
So you think you make somewhere approximately around, on average, 2,500 a month? That sound right?
Not this last month, no. Wasn't close to that.
Do you have a rent or mortgage payment?
A what?
Rent payment or mortgage payment?
No.
Do you live with someone?
Kids.
And who would that be?
Arian, Dean, Evelyn, and Sally.
And she doesn't charge you to live with her? Is that right?
I live with my kids. I thought you asked who I lived with.
I did.
My kids.
Are they adults?
No.
So you don't pay rent.
One of them just turned 18.
You don't? All right. So that one's not a minor. How many do you have that are minors?
3.
3?
Yeah.
And are you still supporting the 18-year-old?
She lives with me.
What?
She lives with me.
Well, are you paying for her food? And
Yeah.
how is it that you don't pay rent?
I own my home.
All right. Is it paid for in full?
Yes.
And what's the value of it?
Not a lot.
Is it agreement?
What's that?
Is it here in Eureka?
No.
All right. Well, what would you approximate it at?
15,000.
15,000.
Yeah.
And do you pay any kind of utilities on that? How much per month do you pay for water, electric, sewer, gas, trash?
Water around $110 a month. Electricity, probably this month will run around $350 a month. I have another electric bill that for another building that's around $30 a month. And lots for groceries.
All right, and so you're a single person raising 4 children, is that right?
Yes, ma'am.
All right, so for 5 people, I will find that you qualify and appoint Richard Paw, and you said you've already talked to him. Wait, yeah, this is just a misdemeanor. Okay. Missy, when do they come back?
September 9th at 3:30.
You and Mr. Paul must be back here September 9th at 3:30. Let me check your bond.
Judge, he was bonded on June 17th. The ankle monitor did not get put on him until June 25th. We have put in a 500-foot radius around the victim's house. His mom, this is the case where his mom lives next door to the victim. And she has alleged that he has gone over to his mom's house in between the time that he got out and he got his ankle monitor GPS on. He needs to be reminded he cannot be near there. His mom needs to come to him, not him going to her. If the kids need to go over and see his mom, that's fine. But he needs to stay away from that victim, not talk to her, drive by her, go near her. End of story. Stop.
Why should I just not revoke his bond? Because we made that clear. Mr. Shinkle, I made that clear.
I didn't go near her.
Did you go to your mother's house?
No. Not since since the sheriff's department called me and told me that I had a, whatever it is.
He was over there between the time he got out and the time he got his ankle monitor on.
I made that clear.
No, no. I haven't been there since.
We're gonna start today. And you do not go anywhere near that house where that alleged victim lives. And that means your mother's off limits too, because they're too close. All right. Any questions about that?
How long is this all supposed to go on?
You talk to your attorney, you guys figure that out. Because you're the one entitled to a right to a trial. If we have a trial, it's going to take a little while. But you stay away from that lady and stay away from that area. Otherwise, we'll have to revoke that bond. So, all right. Well, if there's nothing further, you may go. Thank you, sir.
Can I say something else?
Sure.
I was contacted by the GPS monitoring company and they didn't tell me 500 feet. They told me 1,500 feet.
Well, we're saying 500 feet. Miss Gillette, would you notify that bonding company that they've given him too much latitude?
Okay.
500 feet, sir.
Good.
Talk to Mr. Paul about these issues. You'll know how to advise you. Okay, thank you. You're excused.
Thank you.
You're welcome.